We will go on the record in the matter 25 CV 37, Anytime Restoration, Inc. versus Ruth Anderson et al. Appearances are, we have appearing by video conferencing Jack et al., plaintiff's attorney. And who do we have appearing here today?
Good morning, Your Honor. Christopher Grecian, formerly of Helmuth & Johnson, currently with Parker Daniels Keyboard.
Thank you.
Good morning, Your Honor. Anthony Gabor on behalf of Ruth and Dwight Anderson. Seated to my right is Ruth Anderson. Fortunately, Dwight couldn't make it. He's in hospice at this time, so he's not here. Seated behind me is attorney Nate Allen. Mr. Allen is licensed in Wisconsin, and so he is present per the rules as I'm admitted pro hoc BJ.
All right, thank you. I appreciate your formality. Nice to have attorneys who do that. All right, so we're here today. We had a couple motions that were filed, a motion for sanctions, as well as a motion for partial dismissal. However, that has now been withdrawn. So I believe we are only here on the motion for sanctions. Is that correct?
That's correct, Your Honor.
Okay. All right, and the motion was filed by Anthony Gaber. I have reviewed the documents and read the documents, but I would like to hear argument and if you want to provide any other information. So you may begin.
Thank you, Your Honor. Do you prefer that I stand or?
You can be seated by it, but I do appreciate that. Thank you.
Okay. Thank you, Your Honor. As you indicated, we're here on the defendant's motion for sanctions. And so what we are seeking today, Your Honor, is for this court to dismiss Anytime Restoration's claims against my clients, as well as award them attorney's fees for this entire action, and to sanction the attorney and the law firm that brought this action. Because this, we shouldn't be here, Your Honor. This action was brought after many months, actually, after a fire that happened at my client's home in Grantsburg, Wisconsin, September 24th, 2024. And I've sort of laid out in the motion papers, Your Honor, how Anytime Restoration got involved. But here's what's the important thing. A motion for sanctions, Your Honor, can be granted under a number of situations. Unnecessary harassment, frivolous and unwarranted lawsuit that does not comport with existing law, and if the lawsuit is unsupported by the evidence and demonstrates a failure to conduct a reasonable inquiry. We have all three of these here, Your Honor. The timeline here is important. The complaint that was filed on April 11th, 2025. By that date, Anytime Restoration was already on notice of the fact that the emergency work authorization contract that my client signed 2 days after the fire on the 26th of September violated Wisconsin law. And the reason why it violated Wisconsin law is it is what's considered a consumer approval transaction pursuant to Wisconsin statute 423-201. And the reason it is a consumer approval transaction was it was initiated by a telephone call from Anytime Restoration to my client, Ruth Anderson. And because it's a consumer approval transaction, it is required under Minnesota law to contain language informing my clients of their right to cancel the contract within 3 days, midnight on the third day. The contract is part of the filings, so Your Honor can see that there is no language anywhere in that contract notifying my clients of their right to cancel. So there were a lot of discussions that went on once I became involved, emails and telephone calls, but here's the important part. As of April 11th, Anytime Restoration and its counsel knew the following, because on March 27th, I wrote to Mr. Grecian. And I told him that a former Anytime employee, Daniel Lip, had learned about the fire from a friend. Now, in the letter, I didn't identify the friend, but later on, we find out that's John Campbell. And this friend suggested to Mr. Lip that he contact Michael Anderson, who is one of Ruth Anderson's sons. He did so. He asked for Ruth Anderson's phone number, which Michael provided. And then Mr. Lip called Ruth Anderson and set up a time to come meet her. That's why this is a consumer approval transaction. It was a telephone solicitation. So she signed that agreement, paid a $500 deposit as indicated there, and then Anytime Restoration proceeded to literally strip the Andersons' home of virtually everything. I mentioned in my filings that they're literally camping in their own home, and that's not an exaggeration. They took towel bars, they took patio furniture that was outside of the home, nowhere near the fire. They took everything. They took utensils, they took cookware, they took, you name it, they took it, and they still have it. They're storing it, and they want to charge us $4,000 a month to store it. They've refused to give it back. So that's what Anytime Restoration knew as of March 27th. And if you look at that letter, Your Honor, at that point, I was under the impression that Minnesota law governed, because paragraph 27 of the contract that Ms. Anderson signed says so. It says Minnesota law governs. I've since learned there's a Minnesota statute that applies, that a contract like this, Wisconsin law will govern even if the contract says another state's law does. So on April 8th, 3 days before the complaint was filed, I wrote again. And at that point, I wasn't quite sure Wisconsin law applied. So I continued to cite Minnesota law, but I also cited the Wisconsin law that applied. And I said, even if Minnesota law doesn't apply, Wisconsin law applies. 3 days later, Anytime Restoration files their complaint. And in paragraph 7 of the complaint, they indicate that a member of the Anderson family contacted Anytime Restoration to inform it regarding the fire and the services that Anytime provided. That's wrong. And they knew that before they filed the complaint. And that's the primary issue here is, as Your Honor knows, Wisconsin law requires that an attorney conduct a reasonable investigation into the facts before filing the complaint. So 2 weeks before they filed the complaint, they were on notice that what they later alleged was not how this happened, and that this is a consumer approval transaction and that it's void. Here's what should have happened. They knew that Daniel Lip was a former employee. They didn't even try to contact him. You'll see in his affidavit, no one from Anytime Restoration has contacted him. Wisconsin law, I assume we're going to hear that the attorney, Mr. Grecian, called his client, and this is what he was told by his client. You can only go by what your client says. Well, Wisconsin law provides that you can't just rely on what your client says, especially if it's not direct information, it's hearsay information. So here we have a client or an attorney who's relying on their client's story when the Andersons have made him aware before he filed the lawsuit that his version of the facts is wrong. They do nothing to investigate the claim. And then they go ahead and in response to our answer and counterclaims, they amend their complaint. And in the amended complaint, if you look at paragraphs 7 through 9 of the amended complaint, they virtually adopt our version of the facts. So I would argue that that is an implicit admission that what they originally pled, that they didn't know what was going on. They didn't know how these parties came together. And by basically adopting our version, that's implicit evidence and an admission that there was no reasonable inquiry made. Now, in response to this motion, they provide Your Honor with the declaration of a D.D. Holznagel that they claim creates a fact issue about whether or not our version of the facts is correct. But if you read her declaration, Your Honor, it's hearsay upon hearsay. She claims that Daniel Lip in some marketing meeting told 5 employees at Anytime Fitness that the
restoration.
Sorry,
Yeah.
Anytime. I've been saying that
Yeah.
throughout.
Very similar.
Anytime. Thank you for the correction. Anytime Restoration, that the version that they originally claimed was what happened. But if you read her declaration carefully, she wasn't at that meeting. She was talking to these employees, so this is hearsay. She said that she discussed it with these employees who are at the meeting. So my question is, if that's the case, where are these, and they reference them as current employees, Your Honor, where are these employees? Why didn't they submit declarations instead of Dee Dee Holtznagel? Because her knowledge is hearsay. Here's the other thing that's not contained in her deposition. In John Campbell's affidavit, he talks about the fact that he got a $500 referral fee from Daniel Lip for letting him know about the fire. And he talks about that. Now, and he says that, or Daniel Lip talks about the fact that that's an anytime restoration policy. They pay people $500 referral fees. She doesn't deny that. She doesn't say that's not our policy. That's not wrong. So if you look at all of the evidence together, there is a complete lack of a reasonable inquiry. In fact, I would say that there was no inquiry into how this lawsuit began. It is clear from the undisputed facts and the facts that you can actually consider, because I would submit to you, Your Honor, you can't consider anything that's in Dee Dee Holtznagel's affidavit. It's hearsay. The undisputed facts, and now the facts that Anytime Restoration has adopted in its amended complaint, clearly show this was a consumer approval transaction. And because it was a consumer approval transaction, that notice to cancel requirement needed to be in there. It wasn't. We canceled the agreement on March 27th, 2025. According to that same statute, the entire agreement is void, including any security interest that Anytime Restoration is claiming it has in any funds. The statute also says that Anytime Restoration is not entitled to any compensation, and that we're entitled to attorney's fees if we bring counterclaims, which we have, or asserted this as a defense, which we have. Now, there's a new attorney involved, and he'll speak in a moment, but he is now making the argument, as you saw in their response, that the insurance company should be somehow equitably stopped from not paying, or my client should be equitably stopped from not paying Anytime Restoration. And he cites a couple of cases to support that. Those cases are factually dissimilar. One of them, first of all, both cases talk about the fact that there were years of negotiation in those two cases between the parties in terms of, on the one hand, was there a settlement or wasn't in the affordable erecting case? In the other hand, was there coverage, insurance coverage or not? In the Nugent case, here there were not years of negotiations, there's months. This happened in September, and we started communicating in March of the following year. In the Nugent case, there was no argument that the underlying insurance policy was valid and enforceable. The only issue was that it expired. And then it was argument whether, because people behaved like it wasn't expired, should the insurance company be equitably stopped. The affordable erecting case is a very limited holding. If you read that case, the Supreme Court said that the estoppel applied in this case to a settlement agreement between the parties. And it was very clear to say, we find that estoppel applies to settlement agreements in this situation. This is not a settlement agreement. This is a contract that was void the moment my client signed it, for the reasons I've illustrated. So for that reason, and the fact that there was no inquiry as to how the parties came together, we're asking this court to, as a sanction against the law firm and the attorney who signed the pleadings, dismiss these claims against my client, all of them, award us our attorney's fees, and sanction the attorney who signed the pleadings and his law firm. Thank you, Your Honor.
Thank you. Mr. Edel, are you going to be arguing?
Well, Your Honor. And I appreciate Your Honor's attention to the matter and getting the order to appear remotely signed early this morning so that I could appear remotely. I do appreciate that very much. First and foremost, I think the most glaring issue with the defendant's motion here is that under 802.05, Wisconsin statute 802.05, when a sanctions motion is brought, it shall be brought as a motion for sanctions under this rule shall be made separately from other motions or requests and shall describe the specific conduct alleged. What the defendants are doing here is basically bringing a motion to dismiss, and seeking a dismissal is not proper under 802.05. There's no remedy under 802.05 allowing for dismissal. The only thing that can be awarded or determined by Your Honor in this court is whether or not to apply a directive or a non-monetary nature in order to pay a penalty into the court, or if imposed on a motion warranted in order directing payment to the movement or to the movement. There's nowhere in 802.05 that allows for dismissal of the action. And one of the things that I cited in the responsive motion papers is that based on all of the Wisconsin case law, there must be an order of dismissal or a judgment or something along those lines that would tend to indicate that the factual dispute has been resolved or determined or otherwise dealt with. And by pursuing a motion, by seeking dismissal through this motion, they're avoiding like a very large procedural step, which allows for my client, the plaintiff here, to submit evidence on behalf of itself and contradict or stand behind or offer other evidence that would disprove these affidavits that have been submitted by Mr. Lip and the other witnesses that have provided their affidavits. As to Mr. Gaber's point or assertion that Ms. Holtznagel was not in attendance at that marketing meeting, that is not true. The reading of that affidavit or declaration is extremely narrow. She was at that marketing meeting. That's her firsthand knowledge. And so it's not hearsay upon hearsay. It's very much evidence that would allow for impeachment of Mr. Lip. And therefore, it's not hearsay and extremely reasonable for Mr. Grecian and myself to rely on that particular knowledge and information, as well as discussing with the other employees. Here's the other issue too, is that at this particular juncture, there hasn't been discovery and there hasn't been a coming forth of all of the evidence to defend against this. And there's numerous other Anytime employees that were present at that marketing meeting that can offer evidence to oppose these affidavits. And so there's a glaring fact issue as to whether or not what is said in those affidavits is true. And under the holding of Wind Point Restoration, Inc. versus Weichel, that pinpoint citation is 953 Northwest 2nd, 98. That stands for the proposition and understanding that if the defendants contacted Anytime first, that their assertion of this defense or this statutory defense does not apply. It's an exclusion, and therefore the fact issue is extremely germane to whether or not this statutory defense is even allowed in this case. Second, there is a large fact issue and a legal issue to be addressed here. And you can see that in my declaration, I provided a bunch of emails between myself and Mr. Gaber that talk about, hey, there's this very glaring issue with the defendant's signature of a policy holder release agreement between them and their insurer, UMIC. I said, I've done the research. I can see from this that there is a very good argument for equitable estoppel here, even if the emergency work authorization is deemed a consumer approval transaction. That being said, I believe that we should withdraw these motions and get into discovery and determine whether or not, and basically see whether or not there are evidentiary issues as I've described, but as it pertains to UMIC and their signature of that policyholder release agreement in accordance with the final approved pricing and coverage for this, I said, hey, look, there is legal support for this. There's factual support for this. What do you want to do? And basically, we're here before Your Honor on a motions for sanctions with no determination as to a motion to dismiss. I do believe it's very, very procedurally improper and premature to bring a motion for sanctions, especially at this time in litigation. And based on that, there are basically 802.05 turns and says, hey, look, when a defendant to this motion for sanction is required to respond and put forth its evidence, they can seek attorney's fees and the like. So in response to this, Anytime would request a award of attorney's fees against the defendants in this matter and their firm for an award for attorney's fees in responding to their motion for sanctions.
I see a few flaws in your argument. 802.05 definitely allows for a dismissal as a sanction. That is very, very clear. The court granted it is to be looked at the end of all other sanctions, but 802.05 definitely allows for a dismissal, especially if the court finds that this is frivolous or that other things were violated on behalf of or by the plaintiffs in filing the matter. So that's definitely incorrect. When I reviewed Ms. Hosnagel, Dee Hosnagel's affidavit, it is not clear. It does not state at all that she was in attendance at that meeting. She very clearly states that other employees were in attendance. She spoke with other employees. I read that very clearly in her affidavit, and I can pull it up right now, in which she discussed this matter with the current Anytime employees that were present. They recalled lip stating blah, blah, blah. She did not at any time say, as she stated in the very beginning, that a meeting was held by, in paragraph 5, Lip told the story during a marketing meeting at which numerous Anytime employees were present. I was present as well, would have been in there had she been present. That is not how the court reads and reviews that signed and sworn affidavit declaration from Ms. Holtznagel. Also, you're talking about the defendants in the argument of if the defendants contacted Anytime first, then the assertions wouldn't apply. as Attorney
Gabor.
as Attorney Gabor indicated that if you look at the
And that's where we'll leave this hearing for now. What started as a dispute over a restoration contract has evolved into a battle over whether the lawsuit itself should have been filed in the first place. The judge has already challenged key arguments from both sides, raising serious questions about the plaintiff's investigation before filing the case. But the final decision on sanctions could have major consequences, not just for the parties, but for the attorneys involved as well. So what do you think? Did the plaintiff have enough evidence to bring this lawsuit, or should the court impose sanctions for filing it?
the initial summons and complaint that was filed, which the court did, it indicates in paragraph 7, just as Mr. Gabor stated, that shortly after the fire, a member of the Anderson family contacted Anytime to inform it about the fire and to inquire about the services Anytime provided. We know that's not true because then the complaint was amended, which indicated a family friend of the Andersons contacted Daniel Lipp. I'm not hearing or seeing that the defendants contacted Anytime at all. Response. I don't think I'm looking at this wrong.
No. So there is another member of the family. His name is cited throughout the email correspondence in my declaration. I believe, let me just get this certain.
Your Honor, that's Kyle Anderson. That's
Kyle.
another son
Thank
of
you.
Ruth Anderson. And he's here, by the way.
All right.
Thank you.
So I'm going to pull up
And-
your declaration.
And he's not in any of the declarations because he wasn't involved with the contact with Anytime Restoration. That was Michael Anderson.
Matthew.
I'm sorry.
Yeah.
Anytime Fitness
I
and
read
Michael.
it.
I'm going to
It's
rename
Matthew.
your child. I'm sorry. Matthew Anderson.
I will try and pull up Mr. Edel's declaration, but I cannot find it. Yeah, Matthew. We have a declaration of Matthew Anderson, Mr. Lipp Campbell. Let's see. No, Matthew Lasner.
That's another attorney at my firm.
Thought I had them all pulled up. Let me just see. Yeah. Okay, I have your affidavit pulled up right now, Mr. Edel. And I'm not seeing Kyle Anderson.
He's referenced throughout the email correspondence attached as Exhibit C.
I'm seeing that he was just stated as we're going to get this to him. We haven't heard from him. But you'll admit though that Kyle Anderson is not the party, is not the individual who resided in the home that burnt up in the fire. That would be Ruth Anderson, correct?
That is correct, Your Honor. And
So Kyle Anderson is not a defendant, correct?
that is correct, but it would be my assertion that Kyle Anderson can act as an agent of the defendants by making certain outward
I'd love to hear
representation.
that argument. Love to hear that argument. Because I'm going to tell you, I'm not having my son act as an agent for me unless I have a document that says he can act as my agent. Correct? So Anytime worked with Kyle, wanting to work with Kyle, but Kyle's not Ruth, correct?
Correct.
Okay. What else would you like me to hear and to know, Mr. Edel?